If you make a mistake during your deposition and give the wrong answers, can you actually correct it before the deposition is over? You want to know the answer? Come join me for a moment as I share this walk with you and I explain to you exactly the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is yes, you can make changes to your answers in the deposition. Now, you should know, what's a deposition? A deposition is a question and answer session that's given under oath. It takes place in our office, in our conference room. You see, when you bring a lawsuit, the defense attorney will have an opportunity to go ahead and question you. And by the way, this is so funny. I'm out looking over the lawn, and there's so many bunny rabbits. I'm going to see if I can show you all the rabbits in the background just hanging out. They come out at this hour. This is so funny. There they are. You got a couple of bunny rabbits just hanging out there. All right, so let's get back to the video. Can you make changes to your deposition testimony? The answer is yes, because the questions that you are asked and the answers that you give represent your sworn testimony. Sworn testimony given under oath in response to the defense lawyer's questions. Now, you might think, hey, what's the big deal? It's happening in your lawyer's office. This is a give and take conversation. Actually, it's not. The testimony, the answers that you give, carry the same exact weight as if you are testifying at trial. The only real difference is that there's no judge there and there's no jury present. But all of those questions and all those answers are then transcribed and put into a booklet called a transcript. And now when you get to trial, maybe a year down the road, if you are asked the same questions and give different answers, now the defense lawyer is going to use the prior testimony you gave at your deposition to contradict what you have said now at trial, to show the jury that you are being less than credible. Okay, so what happens if you're asked a question, let's say, when did you next see the doctor? And you say, oh, I saw him in May 1st. And now about 10 minutes later, you realize, you know what? I didn't see him in May, I saw him in June. Can you make those corrections? And the answer is yes, you can. Just tell your attorney, and your attorney will raise the issue with the defense lawyer, and now will say, listen, my client wants to make a correction, he remembers now something different, and the defense lawyer will say, no problem. Okay, what correction do you want to make? Oh, you would ask me a question about when I saw the doctor, and I remember seeing the doctor, not when I said May 1st, I saw the doctor June 15th. Okay, fine. And now you move right along. So there may be other instances where, let's say the deposition is over, and now you've been questioned for many hours in your attorney's office, and now, maybe a month later, you're going to get a transcript of exactly what you said and what answers you gave in this question and answer session. And as you're reading it over, you realize that there are typographical errors. And you make changes. You're told to make changes. Well, what does that mean? It means that now, even though you can't physically go in and cross out and replace what already is recorded, you can go ahead and make changes on a separate page. And that's known legally as an errata sheet, E-R-R-A-T-A. Or maybe there's an extra T in there. I forget how it's spelled. But the point is, if you have to make changes to your deposition answers, there is a process to do that. So you get a separate page out, you write down the page number, the line number, and now you go ahead and put in what the answer should be. And now you'll sign it, get it notarized, and send it back to your attorney. And now that together with the transcript itself becomes part of your sworn testimony. So if we bring that up at trial, or if somebody tries to read your original question and answer at trial so the jury can see it or hear it, guess what? Now we pipe up and we say, hey, judge, wait a second. My client made a correction. And that correction is to that line, that page number. Guess what? That answer is totally different. And now you will be allowed to go ahead and read, or your attorney will be allowed to go ahead and read that question, that answer, and the correction that you made to that particular testimony. So why do I share this with you? I share it with you because it's a gorgeous day today, and now I wanted to explain how these types of cases work. Because a lot of people want to know, hey, if I make a mistake during my answering, during questioning, can I correct it? Yes, you can during the question and answer session, and if you realize the mistake was made, you can do it after as well. You know, I realize you're probably watching this video because you came and wanted to see all the bunny rabbits that are out here. No, I realize you're not there for the bunny rabbits, but if you do have questions about your matter and you have not yet started a lawsuit and are thinking about bringing a case that happened in New York, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.